Good afternoon, ladies and gentlemen. My name is Imad Antoine Ibrahim. I am an assistant professor in environmental law and governance at the University of Twente in the Netherlands. Recently, I published a book entitled International Water Law and the Human Right to Water, the Case of Transparent Aquifers. Based on this book, I'll be making a presentation to explain the concepts and the ideas that were made. In this book, I'm asking a simple question. Can synergies between international water law and the human right to water and sanitation be created, focusing specifically on transparent aquifers? To give background, there are three types of freshwater resources: surface water, groundwater, and water trapped in the ice, in the polar ice. Some of this water are transboundary, others are domestic. In the book, we focused mainly on only transboundary aquifers, meaning transboundary groundwaters. The topic of international water law has been dealt with by a huge number of scholars in the last 40 years. So why bother conducting a new study on the topic? The issue is simple. The main studies concerned surface water, transboundary surface water, and not transboundary groundwater, which is why we are conducting the study and which is why the book was written. The problem is rather political more than legal. This is despite the abundance of proposals and suggestions made by scholars to solve the issues that we will discuss. The development of international water law followed technological advancement in the past. First, international instruments were more concerned about providing a legal framework for surface water. Transboundary surface water gained huge importance in the past as a result of the lack of scientific understanding of the nature, quantity, and relevance of groundwater. Groundwater in this situation was mentioned only and only, I repeat, if it was connected to surface water from a hydrogeological perspective. The main instruments we have are adopted by two main institutions: the International Law Commission, ILC, International Law Association, ILA. The ILC adopted binding conventions. The first one, the Convention on the Non-Navigational Uses of International Watercourses of 1997. We have another United Nations Economic Commission for Europe Convention of 1992. We also have a non-binding instrument called Draft Articles on the Law of Transboundary Aquifers of 2008. The International Law Association adopted several instruments, mainly the Helsinki Rules, the Seoul Rules, and the Berlin Rules. The Helsinki Rules, none of these are actually binding. These acted as a way to push the international community, mainly via the ILC, to adopt the conventions, the binding conventions. Yet, a comparison between existing conventions and non-binding instruments, mainly the Watercourse Convention, the United Nations Economic Commission for Europe, and the draft articles highlight that there are gaps within law and gaps within literature. We will look at these gaps because these gaps resulted in lacuna and conflicts, which is why proposals have been made to deal with that. One of the proposals, and because we had too many proposals, there was a lack of consensus. What are the suggestions? Well, first, adopting the draft articles as a convention covering all types of groundwater resources. That include chargeable and non-chargeable groundwater resources, and that means transboundary groundwater resources. The second proposal, amending the Watercourse Convention of 1997 to take into account all the particularities of groundwater by properly defining it and including those groundwater that are missing from the scope of the convention. Then, there was a suggestion of adopting the draft articles on the law of transboundary aquifers as a protocol to the Watercourse Convention, although this idea did not gain much attention. Finally, why not using the draft articles as a non-binding instrument in the sense of a guidance for states so that they can use it when adopting transboundary groundwater agreements? This is made as there is a huge probability that states would not ratify such a treaty. And that would give this instrument more flexibility. But let's go back for a second to discuss transboundary aquifers. What is the legal status of transboundary aquifers? Are they common good? Are they private good? Are they a human right? Upon analysis, one could say that transboundary aquifers are sort of a quasi-commodity, meaning they are semi-private good, but also part of a human right. So this is what the legal status of transboundary aquifers. So we went from discussing historical development of transboundary groundwater law to the legal status of transboundary aquifers. How about the development of the right to water and sanitation? Well, efforts mainly started after the Second World War, and where the human right to water was indirectly mentioned. Human rights treaties like the two covenants and General Comment 15 on the right to water were then adopted to help in that. Yet, we did not really have a proper human right to water until 2010, where we have the adoption of a human right to water and sanitation, which would be implemented at the national level and even would have extraterritorial impact. Yet, there are problems with this right. First of all, this right, it's not binding in nature. It's not binding international law because it has been adopted via a UN General Assembly resolution. We don't understand how to implement it practically. Water has also a unique special nature. And finally, only efficient regulations can ensure water access and not a human right approach. Now, how do we connect international water law to the human right to water? Well, international water law mentions the concept of vital human need. But at the same time, human right to water concern a little bit the concept of vital human need. So the question that we have in mind is there a room for synergies? Well, upon analysis, there were arguments to use the concept of the human right to water to include it within transboundary water treaties instead of the concept of vital human needs. Why? Because the human right to water has a broader scope. It's already being used as a state practice in many transboundary water agreements at that transboundary level, at the regional level. Finally, that provides a binding force to the right. So, this is why if we try to combine this conversation with the ongoing discussion concerning the final shape of the draft articles, so you have an instrument in place covering transboundary aquifers that is not yet adopted as a convention, a protocol, or it remains non-binding basically. The question thus, should we include a human right to water in this instrument and then adopting it later on as a convention or a protocol? Is this feasible? Well, one would wonder about that first, but from the analysis made in the book, we come up with the conclusion that it would be a good idea to include a human right to water and sanitation within transboundary water treaties, in this case, the draft articles on the law of transboundary aquifers focusing on the regulation of transboundary groundwater. Only time will tell whether the international community in the future will adopt such proposal and include the human right to water and sanitation within such an instrument, which then needs to be discussed whether to adopt it as a treaty, protocol, or keep it non-binding. Thank you very much for your attention.